10 seconds, 5 seconds. Start. It would be for the officers to show what effective steps were taken to stop the misuse. Mr. Ashwini Kumar, learned senior advocate appearing for MCD, contended that since there is a large-scale misuse of residential premises for commercial purposes, it is a physical impossibility to remove the misuser. The contention deserves outright rejection. We have already noted how the misuser has attained such enormity. It is not merely a case of only lack of will to take action. It appears to be a case of predominance of extraneous considerations. The MCD has made several suggestions which, in our opinion, would only result in further postponement of action against illegalities. According to MCD, roads on which there are major violations have been identified. A beginning must be made to stop misuser on main roads of width of 80 feet or more. The names of these roads be published in newspapers, granting violators some time. After that, MCD will place on record the details of the sealing operation to be carried out in the form of an affidavit to be filed within 2 weeks. Having held that the Commissioner of MCD has power to seal, we direct the MCD for taking immediate steps to steal residential premises being used for commercial purpose. With this direction, we dismiss the civil appeals, interlocutory applications and special leave petitions, but MCD is granted liberty to seek further directions from this court from time to time. Learned trial court, however, declined the application on the ground that it had no power to review that order. Miss Bharti again omitted to turn up before the trial court on the next date of hearing. The court was informed that she required permission from the concerned university for her absence. The trial court was informed that her holidays were to commence with effect from 5th of April 2004 and in the circumstances some date during later part of month of April was sought. The learned trial court accordingly fixed 21st of April 2004 for her appearance and recording of her statement. She, however, again filed to appear. Finding that the witness was not appearing in spite of information about various dates fixed for the purpose, a bailable warrant of arrest was directed to be issued against her. Later, however, on an assurance of her maternal uncle, issuance of bailable warrant of arrest was dropped. But in spite of an undertaking by her maternal uncle, she did not appear. Consequently, a non-bailable warrant of arrest was directed to be issued in addition to initiating proceedings against the maternal uncle for acting in breach of undertaking furnished by him to produce her on the date fixed. Against issuance of non-bailable warrant of arrest, she moved an application in this court, which however was rejected. Her request for recording of her evidence through video conferencing was also dismissed. But for examination of 4 more prosecution witnesses after rejection of earlier bail application, there is no material change in the circumstances justifying instead petition. Consequently, the petition is dismissed.